Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. And this really is the final video in this Form 35 and Form 35R inspection contingency video series.
It's a lot of information.
Thanks to
Ken Sachs. Pleasure to be here, guys.
for joining us in the filming of this video.
Yeah.
It's been a great discussion, so thank you so much
a lot
for
of
your help.
information.
Okay, so we're down to the boilerplate.
Okay.
And a lot of times buyer brokers, when they're drafting repair requests, they feel the need to write language that says that that the repairs by seller will be complete by X number of days, right? Is that necessary?
Well, that's already addressed in the contract itself, so that would be unnecessary, redundant. It's already defined.
Right. In Form 35, when buyer and seller agree to Form 35, Form 35 says that any repair seller agrees to make will be completed 3 days prior to closing.
Yes.
And the reason it's important for that 3 days prior to closing is so that buyer has time to do.
Did it really get fixed? To do a reinspection.
Right. And in order to do a reinspection, the Form 35 says that buyer has to bring back their original inspector to inspect the repairs that they had originally recommended.
Yes.
Right? So I will get questions on the legal hotline about repairs that seller made or allegedly made, and then after closing, buyer is unhappy with the condition of those repairs. And here's how I think through this as a lawyer, and I think this is not inconsistent with what most lawyers would think. If that buyer walked into my law office, let's take the real estate brokers out of it, because once we have closing, are there any real estate brokerage services left to perform?
No.
No. So when the buyer is unhappy about the repairs that seller made and now the transaction's closed, buyer properly belongs in a law office and not in a real estate
Correct.
office, right? So this was your buyer, they were unhappy, and you've sent them to me as their lawyer. And let's say that the buyer says seller had agreed to replace the bathroom, which was full of dry rot, and then replace the vinyl on top of the newly replaced subfloor. Okay?
Okay.
And so buyer says, I walked into the house, it's got this beautiful new vinyl, everything was great. But it turns out seller put new vinyl over old vinyl and never replaced the dry rot. So my first question to this buyer is going to be, did you re-inspect? And if the answer is no, my second question is going to be, why not? Because you had the opportunity to do that. The form gave you the right to re-inspect the work that seller had done. And so now my concern as buyer's lawyer is going to be, buyer, how do we get past that due diligence question? You had the right to re-inspect the work that seller did. You chose not to do that. And now you want to sue seller claiming that the work was done subpar. Now, the example that I gave was egregious. Seller simply didn't do the work, period. Mm-hmm. And that's probably not the best example, because a court would be offended by the seller's lie, if you will, about having said they did the work and not doing the work at all. So let's say it's a different example. Let's just say that they had to do some work, and then after closing, the buyer's not satisfied with the way the work was done. Seller did the work, buyer thinks it should have been done differently. Then my question to the buyer is going to be, did you re-inspect? And if not, why not? And honestly, buyer, I'm not sure that you are going to prevail in a courtroom if you can't get past the burden of due diligence. So buyer brokers, make sure you've at least brought to your buyer's attention their right, their contractual right to re-inspect or to inspect the work that the seller has done by hiring buyer's inspector to come back into the home and inspect the work that seller performed, right?
Absolutely. It's in the contract. Seller already agreed to it.
Right. Okay. So, and then buyer brokers, if buyer says, I'm done with all of this, I just want to close the transaction and move in, which they're inclined to do, that's fine. That's buyer's choice. But you put in writing in an email, as we discussed, you have the right to bring in your inspector to re-inspect the work that was done. You instructed me that you don't want to do that. You're looking forward to closing, or whatever you say in that email. By the way, how was little Sally's birthday party? And then maybe buyer will respond to that, and you can print off the reply in your initial email, put them in your firm's transaction folder. Material communication, and we've got that locked down, right?
Yep.
Okay. Another thing I see brokers wanting to do is write into their 35R that seller will use a licensed and bonded contractor. Now, we're not going to worry about that if you've gone you properly follow the steps of getting a bid and attaching it
Right.
and asking the seller to hire that contractor. But if you are still asking seller to hire their own contractor, a lot of times brokers will write in licensed and bonded contractor. Does that conflict or supplement in any way the existing requirement in the boilerplate language that seller perform the repair in a commercially reasonable manner?
Commercially reasonable just always seems a little subjective. What does that even mean, really? I think it could mean two different things. And so, I like the idea to just kind of get off that subjectivity and let's say, here's what we want, which is pretty clear.
Right. I don't disagree with that.
Okay.
Some folks would say it could be redundant. I'm okay with that redundancy because I agree with you that it's a little nebulous. At least it's something you can argue about, whether or not it was commercially reasonable. You lock it down if you require a licensed and bonded contractor.
Yeah, eliminate the confusion. We're always eliminating confusion.
Okay. Final thing to cover. What if your buyer says to you, I've seen a lot of houses and I'm satisfied with this one. I don't think we need to do an inspection at all. I just want to waive inspection contingencies. What do you do with that buyer?
Sure. So, which the buyer can do that, well, first we're going to have a conversation about a home inspection, and if buyer still does not want to do one, I'm going to document it the same way we documented that the previous point we were talking about. I'm going to document that. That's going into material communication. And how I'm going to treat the contract is I am not going to not use a Form 35. I'm going to use a 35, and the last box at the bottom of the second page is where the box says waiver of inspection. That is what will be in the contract because I want to establish that the buyer is aware of what they are waiving by using the form.
I couldn't have said it better. That's exactly right. So you're going to document that conversation where you make sure the buyer understands the value of having that inspection and their choice. It's their choice, not yours, not the seller's. They're choosing not to take advantage of an inspection contingency. You have that, follow up that communication in an email, and then you pull out your Form 35, you mark the last box waiver, and that's part of the buyer's offer.
Yes, use the 35 for that.
Okay. And that goes to the seller as part of the buyer's offer.
Yes.
Anything else we need to talk about?
I think we've covered it, Annie.
In 5 videos, we should have covered it. Not a surprise, though, that
It's
this is
a lot of information.
It's a lot of information, and it can be very confusing for new brokers and experienced brokers alike, right?
Yes.
All right. So if you have any questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.